Okay, but today we're going to talk about the Constitution, the characteristics of it, some major clauses, how we change the meaning of the Constitution, and the different types of powers possessed by the national government. So let's start off. Some of the characteristics of the Constitution are, number one, popular sovereignty. That means the people rule. And you do rule. I mean, this coming November, if you wanted to, you could get rid of the entire Texas House of Representatives, change them all, half the Texas Senate. You could get rid of the entire House of the U.S. House of Representatives, a third of the Senate. You could change the president. You could change most of the judges if you wanted to. And you can change a lot of county officials and local officials all in this election. So you really do rule. Unfortunately, a lot of people just don't vote. And so they sort of abdicate their power to people who do vote, people like me, which should be frightening to most people. Secondly, there's also this idea that the Constitution is secular. The Constitution does not provide for a religion, nor does it prohibit a religion. It doesn't say it's a Christian nation or a Muslim nation, anything like that. The idea is that there should be, the founders believed in a sort of a public religion, but nothing in particular. So there's this idea that it is secular. Number three is this idea of separation of powers, which came from a man named Montesquieu, that we have three different branches of government, and that allows for checks and balances and limited government. So now let's hit some of the major clauses of the Constitution. Number one is the Supremacy Clause. The Supremacy Clause says the Constitution is the supreme law of the land. That's pretty easy. So if federal law conflicts with the Constitution wins out. If state law conflicts with the U.S. Constitution wins out. If national law and state law conflict, national law wins out. So the Constitution is the supreme law of the land. The next clause is what we call the full faith and credit clause. States have to give full faith and credit to other states' public records, judicial proceedings. What this means is that your birth certificate is good in every state. And now we see that your marriage certificate is good in every state. And this was, of course, controversial during the beginnings of the gay marriage, same-sex marriage, that some states allowed and some didn't. The third clause we want to mention is the Privileges and Immunities Clause. This means that you have the same rights as citizens of the other states. But if you want to open a business in Oklahoma and live in Texas, you have the right to do that. If you want to move to California, you can do that. If you want to move to Texas, you can do that. You have the same privileges and immunities of citizens of the different states. A couple of exceptions to that. One is voting. You've got to be a resident of that state to vote. And two is probably where you're at right now is in school. You will have to pay out of state tuition. Next up is number four is extradition. Extradition means that if you've been accused of a crime or been found guilty of a crime and flee to another state, they can get you extradited, sent back. There's nothing forcing another state to do it, but they tend to do it. Now, if you flee internationally, then usually the United States has to have an extradition treaty with that country. So now let's move on and talk about some of the things that you can't do in the Constitution. One is you can't pass ex post facto laws. You can't pass a law and then punish people for doing whatever you passed a law against when they were doing it when it wasn't against the law. Does that make sense? So in other words, like in my city, if you were planting some obnoxious weed, not like weed where you smoke, but like some terrible plant, and you put it in the ground and the city passes an ordinance, we can't force you to take it out of the ground at that point. That's after the fact. We can stop people in the future from planting it, but we can't do anything about the one you did in the past. We can't fine you or anything like that. Also, in the Constitution, they cannot suspend the writ of habeas corpus. The writ of habeas corpus is that the government should not be able to arrest you without charging you with a crime. Now, Lincoln did this in the Civil War in Maryland to reduce secessionist sentiment in Maryland, thus violating the Constitution. So if you're arrested, you have, I believe, 72 hours before they have to charge you with a crime. If they don't, your lawyer will ask for a writ of habeas corpus. A writ, W-R-I-T, is a court order. Habeas corpus means to free the body, either charge you or let you out of jail. You cannot pass bills of attainder. Bills of attainder are laws that just sort of send you straight to jail without a trial. This came out of the British experience. And finally, you cannot grant titles of nobility. That's not allowed. So let's talk about how you can change the meaning of the Constitution. Well, obviously, the most obvious way is to amend the Constitution. Now, if you want to amend the Constitution, it's difficult because we've only done it 27 times in over 200 years, and we did it 10 times the first 2 years. It's only 17 times in about 220 years have we done it. So the first thing that has to happen is both houses of Congress have to propose an amendment by a 2/3 vote. Each house has to do by a 2/3 vote. As you can imagine, that'd be difficult to do today. Then it has to go to the states to be ratified, and then you need 3/4 of the states to ratify it, which is 38 states. So the last time we got an amendment passed was in 1992, which is the 27th Amendment. But that had been an amendment that had been proposed by Madison and was still sitting out there. The last original amendment that we can think of that came in and was passed shortly after would have been the 26th Amendment, which lowered the voting age to 18 during the Vietnam War. Now, another way you can change the meaning of the Constitution is have a constitutional convention, have a con-con, if you will. And to do that, you have to have 2/3 of the states request Congress call a convention. Doesn't mean Congress has to, it's a request. Now, if Congress responds to that request and there's a convention, any changes have to be approved by 3/4 of the states. And you can't limit the convention. The convention can come in and wipe out the Constitution and write it all over again. Right now, you see a move on to that. Governor Abbott, the Texas governor, wants to have another constitutional convention. Those things always tend to worry political scientists because you don't know what's going to happen out. And we've only had one constitutional convention, 1787. Now, there's some other ways you can do it too, and one of them is through custom and tradition. George Washington served 2 terms, and he said, well, I think that's enough. And out of tradition, no one ran for more than 2 terms up until FDR, 150 years later. People would say, well, Washington said no more than 2 terms, and so you would step down after 2 terms. It became a tradition that somehow changed the meaning of the Constitution. One of those traditions that's still in existence today is that the fact is that the Constitution says that you have to live in the state you represent. That's it. You could live in El Paso, but represent a district in Arlington or in Tyler. But out of tradition, people live in the district they represent. So those are that's how custom and tradition can do it. Another way is through statutory elaboration, passing laws that subtly change the meaning of the Constitution. Because if you look at the Constitution and it says the government can spend money for the general welfare, what did that mean really in 1787 or in the 1790s? It probably meant roads, maybe a canal, ports, and that's about it. Today, when you think general welfare, because of the laws that have been passed, it could be Medicare, Medicaid, Head Start, healthcare programs, environmental programs, educational programs, a vast array of things that the founders had really never thought of back in the 1790s. And then last but not least, another way you can change the meaning of the Constitution is through what they call judicial review. Judicial review is the power of the Supreme Court to declare a legislative act, something Congress might do, or an executive action, something the president might do, as being contrary to the Constitution and therefore null and void, no good. Now, the Supreme Court got this power because they gave it to themselves in 1803 in the famous case of Marbury versus Madison, which we'll probably talk about a little bit more in Unit 4. It's a fascinating story if you have a chance to read it. So now let's talk about the different types of powers possessed by the national government under the Constitution. The first type is what we call delegated powers, sometimes also known as expressed or sometimes known as enumerated, that they're actually listed in the Constitution. The power to raise an army is listed in the Constitution. The power to coin money is listed in the Constitution. These types of powers are important because we operate under limited government. Our government can't just do whatever it wants to because it feels like it. It has to find justification for its actions in one of those powers. So if they're making quarters and people go, where do you get the power to make quarters? They can point to the Constitution and say, well, it's right there where it says we can coin money. All right, that makes sense. So we operate under a limited government, and therefore the government has to find justification for its actions in one of those delegated, expressed, or enumerated, books change and what they want to call them, powers. or in one that can be reasonably implied from those delegated, which brings us to our second type of power, which are implied powers. Implied powers are powers possessed by the government through inference. They're implied, they're suggested. And they get their source of strength from Article 1, Section 8 of the Constitution, known as the Necessary and Proper Clause, which empowers the government to do all things necessary and proper to carry out its delegated functions. So, for example, if a delegated function is to raise an army, it can be considered necessary and proper to have a draft. And we'll talk about this case a little bit later too, if you look at the idea of, it says in the Constitution the government can coin money and regulate its value. Well, how can you regulate the value? Well, how much is in circulation? How do you determine how much is in circulation? Well, Hamilton came up with the idea, let's have a national bank. And then the bank would be able to loan money out, spur business, and the more money they loaned out, the more money was in circulation. That would mean money would be worth less. And the less money they loaned out, less money in circulation, money would be worth more. They're regulating the value of money. Of course, it doesn't say you can build a bank in the Constitution. Somebody did sue in the famous case of McCullough versus Maryland, and the Supreme Court upheld the doctrine of implied powers. And in fact, they also upheld the idea of intergovernmental tax immunity, which governments can't tax each other, but that's another story. The next type of power is what we call resulting powers, and you may not find these in your book, but they're just an extension of the implied powers doctrine. Resulting powers are powers that result from a combination of delegated and or implied powers. You put several powers together and you get a new power, like printing paper money. All right, so you print paper money, where does the government get the power to print paper money? And that was a big question back in the 1800s, late 1800s, when they started printing greenbacks. You can't say coin money because a piece of paper is not a coin. And so there was a series of cases called the legal tender cases. And if you look on your dollar bill, it'll say legal tender on there for all debts, public and private. And the Supreme Court said, well, if you put together the power to regulate commerce, which is in the Constitution, and the power to regulate the value of money, plus the implied powers clause, the government gets the power to print paper money. Now, the last power we want to talk about is the power of what we call inherent powers. Inherent powers are powers possessed by the national government just because they're a nation among nations. The idea is that as soon as you become a nation, whether you have a constitution or not, you have certain powers, mainly in the international sphere, to control your own borders, to conduct trade, to conduct diplomacy. It's primarily in that field of foreign affairs. And this idea of inherent powers is really expressed in a Supreme Court case in the 1930s, the US versus the Curtiss-Wright Corporation. Okay, so that was fast. So what we're going to do next time on the last lecture, I got one more actually, we're going to show how we divide power up between national and state governments. And then I will do a review for our first exam. So good luck, and I will talk to you soon.